unfair.
Yes, Doctor.
In fact, it is fair. We know that
please,
what is the
please. One person goes on air, Masha, the other person says the reference is not maintainable. We will address these issues.
You won't be able to.
You answer.
Let us leave
You
it.
answer, and we will answer you. My only request, my lord, is this.
Yes.
There is a certain slack we might require in your lordship's timing. We appreciate, my lord, that this is the busiest court in the world. You are overwhelmed in a way in which no court in the world is overwhelmed, whether it's 136 or whatever it is. The time that your lordship can give, Lord, is very important. And I would just say that in the light of what has been said, our reply is important. In the 370 case, our reply was curtailed, my lord. If required, your lordship may give us time. That's my respectful submission. My lord, I remember G.L. Sanghi was asked to curtail his arguments. Krishna, I rang him up in the evening and said, your item is number 1, please continue. These are, my lord, traditions, and I know that the Chief Justice, and I've commended it, is so patient in listening to arguments. It is admirable.
Seven will ensure. Don't worry about the fact. Ultimately, our conscience has to be satisfied that we have heard both sides fully.
Right, and our reply.
The reason why we set down time limits is because then people have a broad indication.
No, Lord, I understand.
There's no repetition by
time limit, Lord.
Yes.
Your lordships are overwhelmed. Now, my lord, let me begin by saying about the reference. I want to read the 2 reference orders to your lordships, because the significant thing in the 2 reference orders is this, that normally when a reference is made, the points of reference are itemized by your lordships. This has not been done in this case. So I've taken the liberty, my lord, in my written submission of itemizing what draws from the 2 reference orders, the first in 81 and the second in 2019. So let me take your lordship straight away to those 2 particular orders. Because it's important your lordship should itemize what the point of reference is.
We get them in volume 3A, right?
3A, absolutely. Show me both, 209. I'm sorry, I'm a Luddite, my lord. I'll have to use the printed text. So much better. One day, my lord, I will learn. That's a promise. My lord, kindly turn to...
I thought we could have started with this matter.
It should start with this matter. I'm learning, my lord, I'm learning.
Hello.
I am. I appreciate this, my lord. And when I interact with my colleagues, they're brilliant at this, in a way in which we never were. Anyway, kindly turn to, what is it? That's the PDF? 209. So this was what said by a bench presided over by Justice Fazal Ali. It says, after hearing the parties, we are clearly of this opinion that this case involves 2 substantial questions regarding the interpretation an institution changes
in view of the broad principles laid down in Aziz Bhasha. Even as several jurists, including Mr. Sirwai, have expressed the correctness of the decision of this court, since the point has arisen, we think that it is proper when a larger bench can consider the aspects fully. We therefore direct that this case may be placed before the Honorable Chief Justice for being heard by a bench of at least 7 judges, so that Aziz Bhasha may also be considered and the points that arise directly to the essential conditions or ingredients of the minority institution may also be decided once and for all. Then a reference is made to the various criticisms which the court noted. A large number of jurists, including Mr. Sirwai, learned counsel for the petitioner, Mr. Garg, and interveners Dikshit and Taskar, have also stated, Mr. Garg and interveners Dikshit and Taskar have also stated that this case requires reconsideration. In view of the urgency that this matter may be decided as early as possible, we gave liberty to counsel to mention it before the Chief Justice. So here, my Lord, is a clear statement. Of course, that reference was not made eventually. But we have now to consider the reference that was made by my Lord Chief Justice Gogoi. Your Lordship may come to 216. The point I'm going to make is there are so many things mentioned in this reference that your Lordships will have to formulate, and we will assist your Lordship to formulate what the points of reference really are. Maybe all these arguments, the reference is bad, etc., can be looked at after the event. Now, my Lord, 216 begins with Aziz Bhasha. In our mind, it's clear that the community will have the right to establish and administer of their choice, meaning thereby, where a religious minority establishes an educational institution, it will have the right to administer it. An argument has been raised to the effect that even though the religious minority may not have been established, it will still have the right to administer. When I get to Aziz Bhasha, my Lord, I'll read all of it, but kindly come to page 218. Very interesting comment, my Lord, your Lordships have made, which really, in a sense, takes us much further, where in paragraph 2, it is said the judgment of the Allahabad High Court, which is under challenge, rejects the prayers made on account of the decision of Aziz Bhasha. This is the effect of Aziz Bhasha. That after 1968, it has quelled all understandings of Article 30. Then, my Lord, a mention is made of Anjuman Rahmania, which is the 1981 case. And then, my Lord, your Lordships will see in paragraph 4, it mentions TMA Pi. What is the effect of TMA Pi? It's crucial, my Lord, in our understanding of what this is. Your Lordships will then come, my Lord, to page 219. Where a question was raised in TMA. Now, Yashpal, my Lord, looking at the UGC Act, which Aziz Bhasha refers to, but nevertheless, it does it. UGC Act, my Lord. Now, my Lord, what do we do with Yashpal? And then, my Lord, over the case 221, having regard to the background as stated above, when the precise question was already referred to the 7-judge bench but not answered, we are of the view that the present question set out above should be referred. Now, what is to be taken into account, my Lord? TMA Pi is to be taken into account. Yashpal is to be taken into account. Yashpal, my Lord, says that when you want to establish a university, it has to be done by statute. This is section 23 of the UGC Act as well. Now, the point would be, it means that wherever there is the establishment by statute, you are not entitled to be a minority institution. This will affect a large number of institutions, my lord, in this country. Your lordship is the chancellor, my lord, I want to stress that point because I don't think Aziz Basha has understood how universities are administered. Now, my lord, what do we do with the reference? You can pop up and say whatever you like, but we have tried to make, my lord, some sense out of what this is. I've done it in a small paragraph, and will your lordships come to my written submission? Lord, my learned friend says that in 220, Aziz Basha has to be reconsidered is mentioned twice. This is there, my lord, in the reference. But unfortunately, that bench did not delineate what the questions are, which normally, my lord, happens. Now come to my written submission.
Of course, the referring order by Chief Justice Gogoi, Brother Justice Khanna and Justice Nageshwar Rao refers to the questions which were formulated in Justice Fazal Ali's original order. Says that, well, those questions were never answered. No. No, there were two questions which were formulated by Justice Fazal Ali. In fact, he began by saying two questions arise.
Yes.
He didn't formulate them as one and two, but it's obvious on the first page the learned judges formulated the two questions.
But the very fact that it refers to 2MA Pai and Yashpal has to be taken into account, my lord. It's as simple as that, my lord. Now, my lord, finally,
questions were formulated by Justice Fazal Ali is referring
to some extent, my lord. To some extent. But this court looked at the later decisions of this court.
and the later developments which have
That's
taken
right.
place as well.
Now, my lord, kindly come to my written submission. This is volume 1A.
Because you have the 2004 Act which comes in, then Yashpal is.
That's right,
And
my
then TMA Pai tells us how do you define a minority? It doesn't
That's right.
tell. TMA Pai doesn't deal with establish and administer, but it certainly has some bearing on the issue because it does.
Of course, and its consequences. Because your lordships are always concerned with the consequences of an interpretation. Kindly come, my lord, to my written submission.
That would be volume.
The 1A.
One.
Would kindly turn to page 7, where I've summarized. I'm sorry.
To Dr. Dhawan.
Now, my lord, after what I've read to your lordships, I've dealt that. Kindly come to page 8, 1.5. To my mind, my lord, since Yashpal, and of course there's the National Minorities Act, my lord, which is very important, I have, my lord, indicated what the possible reference could be. And that your lordships will find at the bottom of page 8. May I read it, my lord?
Yes.
Now, my lord, at the bottom of 8, I've succinctly put what the reference should be. Whether the decision in Aziz Basha is internally contradictory in its reasoning on facts and law, contrary to the authoritative decisions of this court, rendered nugatory by subsequent statutory changes and contrary to the constitutional dispensation of Article 30. This covers, my lord, the later portions and the earlier portions. Now here, my lord, I put the issues that arise from this. The first is, was Aziz Bhasha correctly decided, and whether it suffers from internal contradiction and reasoning on facts and law. This, my lord, I'll place Aziz Bhasha before your lordships. Did Aziz Bhasha need to be considered in the light of earlier and subsequent decisions of this court? What is the effect of Aziz Bhasha in the future decisions of the Allahabad High Court, which applies Aziz Bhasha completely and strikes down the statutory amendments through the 81 Act? My lord, when we went to the Allahabad High Court, Chief Justice Ray simply said, this problem of Article 30 and Aziz Bhasha is by a bench, authoritative bench. We have to follow it. There's nothing more we can do. Of course, the judgment is piquant, but we are not at present, my lord, in appeal over the Allahabad judgment. I appreciate that, my lord. We can certainly place it before your lordships, but I don't think it's necessary. Maybe that's in the light of your lordship's decision. Maybe, my lord, that can be done by the smaller bench. Now, my lord, what is the effect of the National Commission of Institutions Act, read with the University Grants Commission? Should Aziz Bhasha be reconsidered in the light of the NCMI and read with UGC by Yashpal? And, my lord, was Aziz Bhasha correct in accepting the antecedent historical data on ANU's Muslim character, but denying its constitutional significance while deciding the issue of its minority status, which is at variance with St. Stephen's, Proust, and Pathak? Then, is Aziz Bhasha contrary to the constitutional dispensation? My lord, that's the sixth point. These are the issues that arise, and I've dealt with them in seriatim. Because we have to, my lord, whether we like it or not, cull a reference from the two reference orders. Now, my lord, I want to begin by saying, before I go into the preliminary objections that we want to raise, my lord, Lord, I think your lordship will bear in mind that India has a diversity which is more than continents and any other country in the world. Your lordships have listed they've listed only 22 languages in the 8th schedule, but in actual fact there are much more. As you go across even my state of UP, you will see the variation as it goes, and they want to preserve that language. Tulu, my lord, that is the basis of TMA PIEs. Therefore, your lordship will bear in mind that this enormous task before your lordships, which TMA PIE squarely places in talking of secularism, and then there's this very elegant passage, my lord, at the end. Very evocative, my lord, but very important. So when your lordship gets into this question, my lord, your lordship is deciding something that goes to the heart of Indian secularism and to the heart of the diversity of this country, both in terms of language as well as religion. This is so crucial to our understanding of the Constitution. Of course, in 1920, there was no Constitution. But subsequent developments have taken place. In 1950, a Constitution comes. 56, the UGC Act comes. The Minority Act comes. And there's a load of decisions, Lord, which say, look at the historical antecedency. Aziz Bhasha looks at it and says it's now irrelevant because we have decided that the Act, in fact, established. What happens to that rich history, my lord? Mr. Sibal will also comment on it. What happens to that rich history? Throughout the world, my lord, there are minority state institutions. Your lordship went to Harvard. John Howard came from Emmanuel College, my college, my lord, and we still exchange with Harvard. If you look at America across the board, and if you look at India today, private institutions and minority institutions are the heart and soul of Indian education. You can't deny it, my lord. And that is why Justice Kripal says, so what if they're 80? They don't lose their minority character. You can't withdraw recognition. This is one of the points that is made in TMAPI. Pleadings and affidavits in the present litigation in the absence of any change in circumstance or new material. The Union of India, my lord, has always defended the statute. In Aziz Basha, they defended the 1951 and 65 Act. And when we were in Allahabad and before this court, when your lordship gave a stay order, the Union of India took the view that Aziz Basha was wrongly decided. The history should have been taken into account. And how can it change its stance? How can, because of a regime change, how can, my lord, we say that because of the regime change, we change our stance? It can't be done, my lord. I await, my lord, the solicitor's response to all this. And when that response comes, we will reply. But just let me take you to one or two passages on page 10 onwards. What the Union of India does, my lord, in 2.2, in view of the foregoing paras in general and particularly in view of the judgment of the Supreme Court in Aziz Basha, the Union of India has decided to withdraw its earlier stance taken by the government to support the minority institutions, the status of Aligarh Muslim University. The SLP filed in the Supreme Court in 2006 in support of the minority status of ANU may accordingly be treated as withdrawn. Now, of course, your lordship has to give permission for this. That hasn't happened. We've responded to this as well. Then, my lord, your lordships will see, I've said the Union of India's volte-facing. We have taken, my lord, the petitions have been opposed by the Union of India, and its main contention is that the Aligarh University, established in 1920 by the AMU Act, and that this establishment was not by the Muslim minority, but the government of India by virtue of a statute, the 20 Act, and therefore the Muslim minority could not claim any fundamental right to administer. So if you're not established, the question of administration doesn't apply. Sorry? Yes, Lord, in Aziz Basha, they defended the statutes. Now there is a change of regime. Till 2005, they take the view that this is right. Mr. Gopal Subramaniam, my lord, appeared in the Allahabad High Court, both for the Attorney General as well as the government. We came here, my lord, we came before your lordships. The stance, my lord, in the stay order, at which some stage I will show your lordship, was no, Aziz Basha is wrong and the judgment of the Allahabad High Court is wrong. So your lordship said that as far as the reservation is concerned, stop it. And AMU agreed. But as far as the other things that you do, that is within 25 miles of the kilometers of the mosque, you will keep your minority institutions and Muslim institutions intact. Then, my lord, over the page, and this I reserve for my right to reply, I've given two decisions as to whether the stance of the government can be changed or not. And the decisions basically say, if there is a policy change, it's different. But this is more fundamental. There's a constitution in place here. And my lord, it's idle to argue that before this that took place. Now, there is some discomfiture in the select committee, which Justice Vanchu, my lord, points out. But the select committee majority takes an entirely different view. So, my lord, our view is that the Union of India stance is a defiance of the Parliament's recognition in 1981 that AMU is indeed a minority institution. It's contrary to the pleadings and submissions made before the Allahabad High Court and this Honorable Court. Now, my lord, I need remind your lordship of Sanjeev Coke, which says that mere affidavits, my lord, will not solve the problem. Then, my lord, I sum up in 2.12. It is the duty bound to defend and follow the will of Parliament expressed to the 1981. The Union of India is not going to defend it, having defended it. Then, my lord, it failed to file a justifiable ground for reversing their consistent stand since 1981 at the governmental level and before the Honorable Court and the Allahabad High Court. In these very proceedings, its failure to state that any new material or legal developments to justify this stance is arbitrary, reasonable, and go to it on merit. Starting with Aziz Basha. Before that, my lord, may I take your lordships to Article 30. Constitution. For the heart and soul of secularism as far as minorities is concerned. Minority protection started in 1909. When reservation was made, 1919, 1935, and of course our Constitution. Now have a look at the importance of Article 25 to 30. This is the crux of the understanding of what has to be done in this multi-diverse country. Because take away the diversity, there are all kinds of assimilations that are at present taking place, my lord, in our country. But take away this particular aspect and the entire color of our constitution and governance changes. Now, my lord, kindly come to 25. कहीं ना कहीं मिल जाएगी दे दो ठीक है Now, my lord, 25 and 26 are important.
And Aziz Basha went slightly wrong, my lord. in its understanding of 26. In Justice Kripal's judgment of TMA Pi, he says 26 will also give you a right to establish institutions. Aziz Basha says, since you're out in 30, how can you have a right under 26? Now, my lord, there are two concepts of secularism, my lord, in our constitution.
The first comes from 25(2)(a), where it says, regulating or restricting the economic, financial, political, or other secular activity which may be associated with judicial practice. This is where secularism is mentioned. And this is the negative view of secularism, saying that these rights will be subject to secular. This is a very narrow view. The wider view that your lordships have taken on secularism, my lord, which is writ large over your lordship's decisions, is what we understand as part of the basic structure. Narrow view, my lord, simply says you can regulate this activity. Then, my lord, if your lordships, I've taken you through the 26, 28(3) is important because it mentions aid and that you cannot, because of the aid, that there are some limitations on what you can do. This is now fully explained in TMA Pi and not fully explained in Bhasha. Now, my lords, kindly come to Article 30. I am not going into the controversies, my lord, of 29 and 30. That 29(1) is a limitation on 30. All that has been decided. It's not. Now come to 1A. We needn't bother about that, my lord. But the main provision of 30, all minorities, whether based on religion or language, this is the diversity provision, shall have the right to establish, this is important, establish what? And administer educational institutions. Now, this has to be read conjunctively. I have no doubt about that. But one point that your lordship should notice is this. What is a minority is something anterior to this. Established and administer are the rights that flow from the recognition of a minority. It's very important, my lord, that your lordship should settle this. Now, my lord, what is it that makes a minority? In my view, my lord, there are three questions. Firstly, the question of origin. Did the origin come from, and where mother provincial effectively is in contrast? I'm sorry, one gets a little excited. Mother provincial says it does not matter even if a single financier comes in para 8, which I'll deal with. That's enough. All this Aziz Bhasha business of not ignoring the antecedency, my lord, is wiped out. The second question, my lord, is the question of nexus. Where mother provincial and other decisions take the view that what you have to look at is whether they found the institution or not. And thirdly, my lord, is the numerical test in TMA Pi. Kerala education did not answer that question. We now know that the numerical test is in respect to the state. Of course, some of us who argued Pi and Lord are not particularly happy with this, because we support Justice Umapal's decision that it depends on the nature of the statute. But in any case, the majority has held this. Then over and above that, my lord, we have to look at the intention, my lord, of the statute in question. What Aziz Pasha does, my lord, and I'll take your lordship to the statute, it ignores the purpose of the statute. The purpose of the statute is writ large that it is of a Muslim character.
Whereas it goes into the question of establish and administer, it ignores the purpose altogether. I'll briefly, my lord, indicate to your lordships what my broad argument on Aziz Pasha is going to be. Lord, Aziz Pasha is, I'm sorry. Lord, it is always the wish of arguing counsel to know what your lordships were whispering about.
Nothing about to some diversion. In a way connected with the matter. Yes.
Of course, I realize. Even more so, my lord, even more so. One thing that I didn't, my lord, emphasize in Article 30 is the words of their choice. Now, my lords, I'll briefly outline first what Aziz Pasha does, my lord, and then take your lordships through the decision.
Of their choice was introduced to indicate that you can have a perfectly secular education being administered in a minority institution.
Yes, yes, of course.
Therefore, you're not constrained to only propagating your religion or your language or your culture. You can have an engineering college. You can have an IT college. That was the purpose.
What your lordships have done is added two caveats to this. Because there was a fear that these institutions will become too insular. I think that's your lordship's point. Don't just talk about that. What your lordships have done, Lord, in Siddhaj Bhai and in TMA Pi, is your lordships have said that these institutions must be institutions of excellence. That's very important, Lord. And AMU and all these, Lord, our understanding of the Constitution is you must, whatever your minority character, must be institutions of excellence.
Therefore, the court has held that any regulation which promotes the character of that institution as an institution of excellence is permissible.
Of course.
So therefore, you must pay minimum salaries to your professors.
Yes.
Because that, if you don't, they will not be an institution of excellence.
My Lord, the other caveat, my Lord, in
Frank Anthony, for instance.
a lot of decisions is this, that where the ordinary law applies, service law, electricity law, whatever it may be,
There's no immunity from the application.
there is no immunity from that. And I make it absolutely clear that AMU and the other institutions must be institutes of excellence. It goes to the core of raising the level of minority institutions. And your lordships have done this consistently on these 2 points. Institutions of excellence and ordinary law will apply to you. But the moment you say recognition will not be given to you, TMAPI says this is not on. Funding, affiliation, my lord, all that will be impediments. I must say, my lord, that in accreditation, AMU has been given A1, A+ in its excellence. Now, my lord, my first point about Aziz Bhasha is this. Aziz Bhasha says universities can be a minority. This is at page 848. I'll take your lordship's through it. Now, if universities can be a minority, and you say that if they are established by statute, they have no protection, this is a contradiction. Because now, my lord, as ever, universities can be established in only 2 ways. Royal Charter, which doesn't apply, applies to high courts but nobody else. And, my lord, statute. Section 23 of the UGC Act, which is noted by Aziz Bhasha, says it must be by statute. At the same time, it takes the view that if you are statutorily established, then you are established by the statute and not your antecedents. Second, my lord, is Aziz Bhasha, my lord, recognizes the background and antecedents role that the MAO College made in building this institution. This it does at page 849, I'll show to your lordships. And it is said, my lord, it is clearly Muslim. The third point that I want to raise before your lordships, because I want to take your lordships to the Act of 1920 and of course the Act of 81. It ignores completely the purposes of the Act. So all the provisions that actually deal with its Muslim character are totally and completely ignored. Now, my lord, there is one thing, and your lordships will appreciate that. Aziz Bhasha, my lord, does not wholly understand how universities are run. It mentions the Governor General, it mentions the Rector. Universities, my lord, have a dual system. Firstly, and your lordships will appreciate this as Chancellor. And this is that you will supervise if necessary, you will inquire. All that is written, my lord, for example, in section 7 of the Bangalore. It's there in NUJS, it is there in Sanchi. So one aspect, my lord, is the external institutions that are kind of suo motu ombudsman. The second part is the statute itself and the institutions of the minority. The emphasis in Aziz Bhasha that the rector has this enormous power, my lord, is unfounded. In all universities, the rector later became the visitor. In all universities, the chancellor, the rector, or the visitor has this supervisory power, and that will not, my lord, interfere at all with the minority status. My next point is, my lord, that Aziz Bhasha ignores the alternative meanings to establish. This is relevant for our understanding of Mother Provincial. It also understands but misunderstands the importance of recognition. It says recognition, why is that? That takes everything away and you become really nothing more than an institution of government. These are the broad arguments, my lord. Because Aziz Bhasha takes a very narrow view of Article 30. Now, my lord, may I take your lordship to Aziz Bhasha? It's volume 3, 3A. Will your lordship turn to 3A? We feel, my lord, it was so much better to hand over the books.
So much better this way.
I know, my lord.
There's no time spent in handing over books.
No,
returning them.
but the point is, one went straight to the point and then the books came out, went into the... So there was a continuity that we had, which is somewhat broken. But that doesn't matter, my lord. I told your lordships I'm a Luddite and I'm amazed that your lordships extended it. Now, my lord, page 3 of 3A is where the head note is. On the head note itself, which I won't read out, but I'll read it from the judgment. It goes into the antecedent history and says it's very important, and then ignores it because the 1920 Act is there. But let me take your lordships, my lord, to the judgment itself. Now, my lord, page 7. The Union of India's stance, my lord, was that it's not a minority institution, but also it defended the statutes of 1951 and 65, which were before the court. Now, my lord, there have been further developments. We have the 1981 Act. How can you now say the 1981 Act? I mean, I can understand that the Allahabad High Court knocked down 3 provisions of the AMU Act because they said it was a usurpation of the judicial power. Now, my lord, the Chief Justice has dealt with this and Pavitra too. I won't go into greater detail about it. Did the 81 Act change the basis, or was it a usurpation of judicial power? In knocking down the preamble and 2 sections, which I'll show to your lordships, in actual fact, they said it's a usurpation of judicial power, and it's non-est. Now, my lord, kindly come to page 8. Here is the history of the establishment, and it says it's necessary to understand it. I'll give your lordships a fuller account. I won't take your lordships through it. Now, 1870, Syed Ahmad Khan says the Muslim community is neglected. Then, Lord, there's a whole list of negotiations, which I'll show to your lordships. He wanted liberal education to Muslims. Then he says, in 1872, the MAO was established. And then, my lord, in sequence of activities, the school was opened. Then Lord Lytton laid the foundation stone. The MAO College was established thereafter, and it is a flourishing institution by the time of Syed Ahmad Khan. Then, my lord, at the bottom of that page, and your lordship has to see that, long negotiations took place. That's the last 3 lines on that page. Between the association and the government of India, which eventually resulted in the establishment of the Ali government. Now that is the antecedent history. We have to review it in the light of my Lord St. Stephen's. The antecedent history is important, because your lordships will see that even St. Stephen's was in fact a constituent college under a statute. All our deemed universities are actually, as Mr. Dwivedi pointed out to the court in Yashpal, are and under a statute. If Aziz Basha is taken at its limits, it could destroy the entire system. Now, my lord, it is mentioned that before a large sum of money was collected by the university, as the government of India made it a condition that rupees 30 lakhs must be collected for the university before it could be established. Further, it seems that the existing MAO college was made the basis of the 1920 Act for the administration of the university, along with the properties and funds attached to the college, the major part of which was contributed by Muslims. This is the antecedent history, and Justice Vancho recognizes this. But he says, I'm sorry, the 1920 Act, they'll go by the establishment, and that's the end of it. Then, my lord, the preamble says it is expedient to establish and incorporate a teaching and residential Muslim university and to dissolve the societies under the Society Registration Act, which are known as MAO. Aligarh and Muslim University transferred to West in the university all the properties and rights of the said societies and the Muslim universities foundation. Now, this is important, my lord, because a continuity was established between the pre-1920 Act and the 1920 Act. This continuity is fundamental to our understanding. Justice Vancho realizes this, but then ignores it. Now, my lord, kindly come to section 3. It also mentions, my lord, opposite place H, that section 4 dissolved the MAO College and Muslim University Association and all the property, movable, immovable, and all rights and powers of the privilege were, my lord, were transferred to Aligarh. This is the continuity in section 4. How can you ignore it? MAO is now being transformed by section 4. Of course, my lord, earlier, because of section 23 of the Act, the court, which was the big body, had almost absorbed it. That was amended in 1951. Now, my lord, over the page. Now, my lord, kindly come to place C. These provisions will show that the 3 previous bodies legally came to an end and everything that they possessed of was vested in the university by the 1920 Act. Of course it was, but the continuity. And nowhere you will see in the Act, as I'll show to your lordships, the Muslim character. Section 6 is important because Justice Vancho finds fault with the fact that the degrees, etc., will be recognized by the government. This is precisely what your lordships have said in Kerala Education and others. Recognition must be given. Then, my lord, your lordships will see 13. 13, my lord, as I pointed out, is a misunderstanding of university education. Because university education, my lord, is based on 2 templates. The external template, which is chancellors, visitors, visiting board. And then it is provided that the governor general should be the Lord Rector. This becomes visitor. later on. And then it mentions at the bottom of the page that the Lord Rector shall give notice to the university of its intention to cause an inquiry.
You said university education is based on two templates. One was the external,
And the internal.
and the internal would be the internal management of the university. How would you define it?
See, my lord, how the university runs. This template is important, and I might mention, since your lordship, Lord, is a chancellor of these universities. Look at section 7 of the Bangalore Act and the Calcutta Act. They're similar.
Then, my lord, your lordships will see section 14, which is now no longer there. But the important point, my lord, is if I'm sorry, my lord, my learned friends want me to read C.
Provisions clearly bring out the final control. It's not a final control. In the template, it is a supervisory control. May I sit down for 2 minutes now?
You, Mr. Dr. Dhawan, there's no difficulty. You don't have to stand and argue.
I noticed that Mr. Parasaran, your lordship, said he could sit down.
I know, I remember that.
And he said no. So I must resist, my lord, and suffer this up to lunch.
You can sit down, doesn't matter.
Dr. Dhawan, this is because of your lower back issue. Please sit down and please sit and argue. That's perfectly fine.
It might aggravate kinds of argument. Out of concern, I'm saying.
And you can move the podium aside. You can move the podium aside and you can have a seat and
Mr. Parasaran didn't have the tax problem. You
you
can.
can come on the side and
Thank you.
in fact, if you have a special chair in your office, I didn't know that this has an issue with your back. You could have brought the chair here and sat on the chair and argued. It's so much more comfortable.
No, that's very kind of you. One must suffer, my lord, the traditions of this court. May I just sit down and place this, lord?
Yes.
Requires a lot of courage, feel very unwell, anyway.
Anyway, my lord, those things should not be told to the court. Now, my lords, kindly come to section 23(2). The Supreme Court, the supreme governing body, would exercise all the powers provided by the 1920 Act. That's page 12, Precedent C. This is the distinction between external and internal. It's a misunderstanding of how universities are run. Sir Ashutosh was Chancellor, my lord, of Calcutta, and he took a very prominent view, my lord, in developing Calcutta institutions at Calcutta University. Now, my lord, I come to section 23, my lord, your lordships will say, see that in the 1920 Act, only Muslims, my lord, were members of the court. The court is the supreme body. Now, my lord, I've already dealt with section 24-25. What is said, my lord, between places F and G is a little sentence. This provision clearly shows that the final power rested with the Governor General. Now, my lord, that's the Chancellor. And of course, his role completely went, my lord, because he appointed only the first Vice Chancellors, etc. But somebody had to do it. Now, my lord, the whole import of this is at the page 13 at the bottom. If anything, some of the important provisions to which we have already referred shows that the final power in almost every matter of importance was in the Lord Rector and the Governor General in Council. Now, my lord, this is misunderstanding the template. The rector disappeared, my lord, and became the visitor. Do visitors have that kind of right to supervise? Very importantly so, my lord. Then, my lord, if your lordships will come to place C, my lord. So, my lord, the internal part is mentioned in 14, but I come to place C. The annexure to the 1920 Act gave the names of foundation members of the court, numbering 120 who were all Muslims and who were to hold office for 5 years. Section 9 was deleted, my lord. Now come, my lord, to page 15. The next substantial change was made with the proviso of 23(1). This is done in 1951, my lord, where while the court becomes the supreme body, it need not be all Muslims. Now, my lord, there is a decision of this court in Gandhi Faiz-e-Azam, Krishna Iyer, my lord, with a dissent, that the fact that you place other people on your board doesn't mean that you lose your minority character. Just as Justice Das says, sprinkling of in DMFI. I'll show those, my lord, judgments as far as required. Then, my lord, if your lordships will come at 16, place F. I must say, I'm more relaxed, my lord. I'm very grateful for your lordships. I'm sorry, my lord. I apologize. Now, my lords, kindly come to F. We shall proceed, that's the third line, just opposite L, on the assumption that the present petitions that Muslims are a minority based on religion. Had he looked at the entire act, my lord, he would have realized what the purpose of the act. Now, my lord, if your lordships will come over the page, we come so, my lord, there is really no dispute that they are a minority. And Aziz Pasha says so in so many words. We accept that it's a minority. We accept the connection with MAO. MAO, my lord, was just the AMU was just the alter ego, my lord. It is a continuity of the MAO Act. Now, my lord, kindly come to page 18.
Page 16 and 17, they say that words establish and administer must be read conjunctively.
I'm coming to that. Of course, my lord. But as I said, these are the rights that flow from Article 30. The indicia of what is a minority, numerically, historical circumstances, the nexus which St. Stephen's and others see, that is the important aspect of which goes to recognizing a minority institution. Established and administer are the rights that follow. So now, my lord, 17, your lordships will see at A. The words establish and administer must be read conjunctively. It reads to give the minority to administer an institution provided as it has been established by, provided it has been established by it. So the more important point is establishment, and the right to administer will flow from it. That's important to note because Justice Vancho recognizes, but where does where does it get knocked out? On the first stage. You were established by statute. So he says, where is your right to administer? It's not there at all. Then, my lord, there is. Now, this, my lord, is all conjunctive and this. I won't go into that. Now, my lord, the three questions on the top of 18 in Aziz Bhasha was whether it was established by the minority, first question, whether the right to administer ever vested in the minority, and even if the right to administer properties came to be the university, the minority before the establishment of Aligarh University, whether it had surrendered, it has been surrendered when the Aligarh University came to be established. Now, my lord, there's a very interesting, at C, just top of C, that paragraph. Before we do so, we would like to say educational institutions are of a very wide import and would include university. Now, my lord, this is a contradiction. On the one hand, you say if it's established by statute, then you have not established it. And this is a far-reaching consequence. And then the UGC Act, my lord, specifically says you must do it by statute and by no other method. And then, my lord, this was not disputed on behalf of the Union of India, and therefore it establishes, it may be accepted that a religious minority had I'm sorry. Template overtaken. No, sorry. Now I was at 18. That there are very, and would include university. Now, this is fundamentally important for the future and what Aziz Bhasha lays down. If universities can only be established by statute, then the first part of Aziz Bhasha says you have not established it. On the other hand, universities are part of the minority character. And the Union of India, my lord, accepted that a religious minority has the right to establish a university. Fundamentally, my lord. Now, my lord, we come to the famous St. David's College, when I show CY to your lordships, he says one line seems to have been relied upon. Now we have looked at it carefully. The reason why David's College was decided in this way was that although it had the right to confer degrees, it was not recognized by Royal Charter. So this is, my lord, the support from St. David's, which I'll show to your lordships if required. And this has been a stinging controversy raised by various jurists. Then, my lord, kindly come to the important part of the University Grants Commission at the bottom of that page. It says at H, my lord, the importance of recognition dependent on the will of the government cannot be minimized. Now, my lord, all the decisions on Article 30 say that you cannot hold back recognition. So Section 6 is right. Now, my lord, at the bottom of that page, it was only in 1956 that Section 22 of the UGC lays down the right of conferring degrees shall be exercised by a university established or incorporated by and under a central act. When we were arguing Yashpal, Mr. Dwivedi made the very important point that this must be read conjunctively. That is, established and incorporated. Then, my lord, kindly come to B. It was only thereafter that no private individual or body could grant a degree in India. Therefore, it was possible for the Muslim minority to establish a university before the constitution came in force, though the degrees would not be recognized. Where are we now? Because we have to take into account the UGC. What is Waziz Basha's implication? On the one hand, you say universities can be minority. On the other hand, you say if it's established, I'm sorry, you have not done it. Then, my lord, kindly come. Next paragraph. There was nothing in the 1920 Act to prevent the Muslim minority, if it chose, to establish a university. This is wholly incorrect. It couldn't have. It could only happen, my lord, by charter or statute. And this is true, my lord, of many acts that we see in that area. The 1922 Delhi Act, which makes, for example, says St. Stephen's as a constituent college. But if it did so, the decree was not bound to be recognized by the government. Well, this is now, my lord, history. You have to recognize it. Recognition cannot stand in the way of a minority character. Then, my lord, it says in the absence of recognition of the degrees, it may not have attracted students. And that is why we find the constitution came into force. Most of the universities were established by legislation. Incorrect. All the universities were established by legislation. Now, my lord, then Aligarh University was also in the same way established by legislation, provided that Section 6, the degrees, diplomas, and other distinctions granted or conferred by persons of the university shall be recognized, as are the corresponding degrees, diplomas, and other academic institutions. Then, my lord, it is clear that even though the Muslim minority could have established at Aligarh 1920 University, it could not insist that degrees granted by such university should be recognized. This is wholly, my lord, at variance with the jurisprudence of your court. Recognition and affiliation, TMA Pai says, cannot stand in the way of the minority character. Then he says, my lord, at G, the enactment of section 6. Therefore, when the Aligarh University, above F, was established by section 6, its decrees were recognized and the institution was brought into existence, which could not have been brought to existence by private individual body, or individual could not insist upon recognition. But the more important part is the enactment of section 6 is a very important circumstance which shows that the Aligarh University, when it came to be established, was not established by the Muslim minority. For the Muslim minority could not insist on the recognition. This is all passé. Your lordships have said otherwise. Recognition is fundamental. When your lordships looked, my lord, at the colleges and the schools, when they were denying recognition, your lordship said, no, your recognition cannot stand in the way. Then, my lord, very important is H. It is true, as it is clear from the 1920 Act, that the nucleus of the Allahabad University was the MAO College, which was till then a teaching institution under the Allahabad University. The conversion of that college, if we may use the expression in the university, was not by the Muslim minority. It took place by virtue of the 1920 Act. This, my lord, is the crucial point. I take your lordships now to D. Now, my lord, at D, it may be that the 1920 Act was passed as a result of the efforts of the Muslim minority, but that does not mean that Aligarh University came into being under the 1980 Act, 20 Act, and was established by the Muslims. This is the error. All along you are saying universities can be minority institutions. And at the same time you are saying the intervention of a statute will deny you that status. Then, my lord, I come to this. It says, my lord, that funditio incipiens and funditio perfections. My lord, this means, the incipiens means at the process of granting recognition. And, my lord, the proficience means, my lord, perfecting it. In actual fact, it's wrong to rely on only the latter. Because AMU was there at the beginning, that is at its inception, and also, my lord, later on when it was established. Now, my lord, we come to a very interesting area at the bottom of page 20. What does the word established use in Article 30 mean? If your lordships will go over the page, it gives the different meanings of the US to settle firmly, to fix unalterably, to establish justice, to make or form as to establish a uniform rule of nationalization, to found or create, to regulate as Congress shall have the power to establish posts, to found, recognize, confirm or admit. Now, my lord, it mentions the Oxford Dictionary, and it says establishment has a number of meanings: to ratify, confirm, to settle, to found, to create. The big criticism of Mr. Sirwai and others is there was a plethora of meanings that you could use, but you didn't. You picked up one, which is there, my lord. We are of the opinion that the purpose of Article 31 means to bring into existence so that the right given to the minorities to bring into existence an educational, and if they do so, to administer it. We have therefore to see what happened in 1920 and who brought the university into existence. Lord Mother Provincial, which is a 6-judge bench judgment, confirmed by TMA Pai, uses the word found. I'll show it to you. It's fundamentally different.
What is the distinction between found and bring into existence?
Well, bring into existence, according to the judgment, is to incorporate, whether by charter or otherwise. Found means you take into the antecedent circumstances. And Mother Provincial at para 8 says that even if a single individual philanthropic does this, it will be found. We're not, my lord, in the process of just a legal interpretation, my lord, of 13. We're in the process of looking at the entire process, and he's absolutely right in looking at those Latin terms at the instance of preparation and, my lord, at the instance, my lord, of founding. Now, my lord, kindly come to the history again at Placetum F. From the history we have set out above, it is clear that those in charge of MAO College, the Muslim University Association, and the Muslim University Foundation Committee were keen to bring into existence a university at Aligarh. There was nothing in the law to prevent them. But that's not true. But if we say found, the connection can be seen between the past and the present. Then comes, my lord, a very important part at H. It may be accepted for the present purposes that MAO College and the Muslim University Education Association and the Muslim University Foundation were institutions established by the Muslim minority. And over the page, it says it was under then, my lord. But if the MO College was to be converted into a university whose degrees were bound to be recognized by government, it would not be possible for those who were in charge of MA College to do so. We come to the same conundrum, my lord, that to establish means to establish by statute. You accept everything about the minority background. Then, my lord, if your lordships will come to Placetum F. So the lordships did not examine the 51 and 65 Act properly. Now, my lord, come to F. Nor do we think the provisions of this Act can bear out the contention that it was the Muslim minority which was administering Aligarh University after it was brought to in existence. It is true that the proviso to 23(1) says no person other than Muslim shall be a member of the court, which was declared to be the supreme body and was to exercise all powers. We've already referred to the fact that the select committee was not happy about this provision and only permitted it in the Act out of deference to the wishes of the prepondering Muslim opinion. How does the select committee, my lord, if the majority is there? How does the minority discomfiture, my lord? The important point here is, if you prove you established, then only you will administer. It is not necessary, my lord, that the governing body must necessarily have Muslims. Gandhi says, nor is it necessary that all the students should be Muslim. Kerala Education Bill and TMA Pai. Then, my lord, if your lordships, after, my lord, noting that the members of the court, the supreme body, shall all be Muslims, this is what is said at place C on page 23. It will then be seen that besides the fact that the members of the court had to be Muslims, there was nothing in the act to suggest that the administration was in the Muslim minority as such.
Wrong.
Have to see the act, my lord. The two templates, my lord, that I have given to your lordships. The external template and the internal template. Then, my lord, if your lordships will skip all this about Article 26 and come to one part, my lord, 24F. The right under Act 26 will only arise where the institution is established by a religious denomination. It is in this event it can claim to maintain it. Now, my lord, TMA Pice specifically says 26 is the right. And you say you can't prove establishment, therefore your right disappears. Then, my lord, I won't trouble your lordships with '27, my lord, is important. This was an argument based on Article 19, but what is important, my lord, if we see the Act, my lord, there is a transition in Section 4 from MA College surrendering its rights. So, my lord, we have MAO College, all its property goes. The old students who are there have to sit the exam. This continuity, my lord, according to this judgment, is broken by the 1920 Act. And therefore, we come, my lord, to place C. Therefore, when the Constitution came into force, there was no property which was held by the Muslim minority. As such, for the property vested in the corporate body, the Allahabad University. Even assuming that before 1920, the property was surrendered, which was the property of the Muslim minority, the 1920 Act put an end to their rights. What transitions take place? You have a college, it gives all its property, it gives everything. And that is the continuity, which is broken now because of the view of the 1920 Act. It is now established that you don't surrender your minority status. So, my lord, these are the contradictions in TMA Pi. It was a Muslim minority, Muslims in Bhasha. Go to the Act. Article 2 Act comes later.
1920.
Another way. This is my copy. For the exception is kept it. in Aziz Basha. On the one hand, it says a university can be a minority. On the other hand, it says if it's established by statute, it can't be. It says the nucleus comes from MAO, but we can ignore it. Now, this, my lord, is simply unacceptable in the light of St. Stephen's and others. The antecedent history is important. And this, sorry. We'll come to that. There are films on lip reading, my lord. Now, my lord, kindly bear in mind that if Aziz Basha is right, no university can be a minority. It's contrary to legislative practice, but my lord, no institution. And a deemed university which has been recognized as a minority was established, in the words of Mr. Dwivedi before Yashpal, by or under the statute. All deemed universities acquire a statutory character. Or you say it's established, a deemed university is established by and under. This implication, my lord, is of important significance. Now let me take your lordship to the 20 Act. Volume 3G, my lord. Three G, my lord. PDF4. PDF5. I've learned a new phrase, my lord, PDF. Your lordship there, my lord? First read the preamble, my lord. In the 1920 Act as it was, my lord, there have been changes in 81. Whereas it is expedient to establish an incorporated teaching and residential university at Aligarh, and to Muslim university at Aligarh, and to dissolve the societies registered under the Societies Registration Act, which are respectively known as the Mohammedan Anglo-Oriental College and the Muslim University Association, and to transfer and to rest in the university all properties of the said societies and of the Muslim Foundation Committee. This is the continuity, my lord, that is there. Now, my lord, just have a look at 2H, my lord, which says university shall mean Aligarh Muslim University. Well, my lord, if you come to 3, I've already explained, my lord, this Governor General power is part of the first template, not the second. Now, the continuity your lordships will see in section 4. Here, my lord, the societies known as so-and-so, so-and-so shall be dissolved, and all properties of the movable, movable and immovable, and all rights and powers and privileges of those societies, and all properties movable and immovable, and all rights and privileges of the Muslim University Foundation shall be transferred and vested in the university. This is the continuity recognized by this act. There would have been no act, my lord, but for the foundation coming here. Then, my lord, all debts, liabilities, and obligations shall be transferred to the university, which is 2. All references in any activity, in any enactment to either of the said societies shall be construed as references to the university. Any will, deed, or other document, I won't read all of it, shall be construed as if the university was therein named instead of the society or committee. My lord, subject to any order of the court may make, the buildings belonging to the MAO shall continue to be known and designated immediately before the commencement of this act. Finally, my lord, subject to the provisions of this act, every person employed immediately on the commencement of this act in MAO shall hold employment under the university by the same tenure, same terms, and then, my lord, pension, as if the act had not been passed. Now, what is section 4, my lord? How do we interpret it? Aziz Bhasha, my lord, interprets it negatively. Our interpretation, my lord, taking into mind the antecedent history, which your lordship now accepts, has to be taken into account. St. Stephen's has a huge, my lord, para on this. It says even the motives, my lord, if you see it, St. Stephen's, even those motives show its character. Now, when Siddharth Shankar Ray was arguing before the Allahabad High Court, he gave 3, my lord, volumes on the motives. I'm not going to trouble your lordships with that one. But clearly there was an institution which in continuity became a university. Then, my lord, 5 come to 2, my lord. All this is ignored, my lord. The Muslim character is ignored. 5, subclause 2, at the bottom of page 6. This is the purpose that has been ignored by Aziz Bhasha, which I mentioned when I basically, my lords, summarized what was wrong. And your lordships will see some of the points in the written submission, my page
14 to 25.
14 to 25. I'll quickly go through that when the time comes, my lord. Now, my lord, what does 2 say? To promote Oriental and Islamic studies and give instructions in Muslim theology and religion, and to impart moral and physical training. This is completely ignored. Then, my lord, if you come on page 7 to 512, after it says to do all other things, at the bottom of that page it says Islamic learning and Muslim theology to promote the interests of the students. This is the purpose of the act. Lord, 7, if your lordship comes to page 7, 12. At the bottom of 12, my lord. I don't want to read the whole of it, my lord, it's irrelevant. What is relevant is Islamic learning and Muslim theology. Now, my lord, we come to section 6. One is, my lord, the power to grant degrees. And that 6 says shall be recognized by the government. This is an absolutely correct, my lord, interpretation of Article 30. Of course, it must be recognized by the government, as all the decisions say, otherwise it will be valueless. Then, my lord, 7 mentions how the government, my lord, said 30 lakhs should be given by an endowment. The nexus, my lord, is there because it is these institutions that have to provide the 30 lakhs. Now, over the page, my lord, there is an interesting provision which, of course, would not stand in our feminist jurisprudence, my lord. I didn't want to disturb your lordship's thinking. Now come to 8, my lord. This won't stand, but it says something about the women are exempted. Now this will not stand, my lord. But the understanding at that time was this was linked with Muslim jurisprudence. And now it is deleted. Then, my lord, 9 shall have the power to make, provided that instruction in Muslim religion shall be compulsory in the case of Muslim students. This is consistent, my lord, with Article 28. And then, my lord, what happened is this was deleted and a choice was given. I remember, my lord, when I went to school, whether I should attend church or not. They had to get my father's permission. And I'm very grateful I did. I wasn't in the choir, but like your lordships, my lord, I could sing Christmas carols. No, my lord.
You also had to give a letter.
Others.
this, my lord, is what was the purpose of the Act? Now, all these provisions, my lord, show what the purpose of the Act was. Grant education to Muslims. Even forcing Muslims, my lord, to attend. Now, that, of course, is deleted. Then, my lord, kindly come to 12, which is very important, on page 8. The university shall, subject to the statutes, power to maintain and establish intermediate colleges and schools within such limits of the Aligarh district as may be laid down in the ordinances for the purpose of preparing students for the university, and may provide instructions in the Muslim religion and theology. Its purpose, my lord, your lordship is very right, my lord, in saying that we can't have these minority institutions as ghettos. Agreed, my lord. They must be institutions of excellence. They must conform to the general law. Nothing in this act takes that away. Then, my lord, if your lordships will come to 13, kindly just 1 second. The Governor General shall be rector. This is therefore, my lord, the rector who becomes analogous to the visitor. And that's where my template comes in. The external authorities and the internal authorities. And my lord, I'm informed by my colleagues that this is verbatim in all the other acts. That is section 13.2. For the rector, read visitor. You've given some examples in volume 4, my lord, that's it. I'll take your lordship. So, my lord, 13 and 14 are taken care of. And your lordship wanted to know what the internal aspects were. Kindly come to page 10. It says, the following shall be officers. So, my lord, the rector and the visiting part are not officers. That's the external part in my templates. Then, my lord, the successors to the first chancellor shall be elected by the court. The court, my lord, under section 23 was solely consisted of Muslims. Then your lordships will see 18 pro-vice chancellor shall be elected by the court. 19, the successors shall be elected by the court. 20, the pro-vice chancellor shall be appointed by the court. And now we come to the most important section, section 23. 22 also, my lord. You will see that the visitor is not an authority of the court. 22. But 23, my lord, is very significant. And although noticed, the implications have not been worked through. Read the proviso. As far as the proviso later went, but as far as the 20 Act is concerned, my lord, and the purposes of the Act are concerned, it says, provided that no person other than a Muslim shall be a member thereof. And this continued till 1951. Now this is, my lord, very important when you come to administer. The court was hands-on, my lord,
in the administration of the university, as is clear from subsection 2. The court shall be the supreme governing body of the university and shall exercise all the powers of the university not otherwise provided for in the statutes. So all this, my lord, is there with the supreme body which consists of Muslims. Today they are non-Muslims, my lord. But the point is, this was the tenor of the 1920 Act. And then your lordships will see in 2, we're only concerned with the recommendations, that's the end of 2, my lord, of the Lord Rector. Now your lordships, my lord, have personal experience of what it is to be a chancellor, what is a visitor, etc. Your lordships may be non-interfering, different from chancellors today, my lord. One day that issue will come before your court also. Already, I'm sorry.
We know that.
Now look at 3, my lord. Subject to the provisions of this act, the court shall exercise the following powers and perform the following duties. This is the supreme body consisting of Muslims. Making statutes and or amending or repealing the same, of considering ordinances, of considering and passing resolutions on the annual reports, of electing such persons to serve on authorities of the university, such of as prescribed by, of exercising such other powers and performing such other duties as may be confirmed or imposed by this act or statutes. The purpose of this is administration will stay with the supreme body. Things have changed a little bit, my lord, but the supreme body part remains the same. Then, my lord, I want to take your lordships to the statutes and ordinances. Kindly come to page 12. Look at J, my lord, on page 12. The instruction of Muslim students in the Muslim religion and theology. The next is important, my lord. The establishment of intermediate colleges and schools and all other matters by this act, which by this act or are to be or may be prescribed. Now this is referring to section 12, that within a radius of the mosque, you should establish these institutions. Then, my lord, kindly come to 28. Come to the proviso, my lord, at the bottom. Provided that no statute dealing with the instruction of Muslim students in the Muslim religion and theology shall require to be submitted or approved for approving. Now, my lord. Page 14, my lord. As an argument, my lord, in subsection 5, the continuity is established. Those students who are in MA college may continue with their degrees. Now, my lord, kindly see the first statutes which are important. The first statutes, my lord, are there in page 16. So this is in statute number 8. The court shall, subject to the provisions hereinafter contained, consists of the following members. Kindly come to class 2. The persons named in the annexure shall be foundation members. The annexure, my lord, which I'll show to your lordship, was completely Muslim. On page 24, I'll come to that. I don't want to get into all this. So, my lord, the continuity is again established on page 19 at the top of subclause 3. The graduates are there and who have been educated in the Mohammedan Anglo-Oriental College and are members of the association recognized for this purpose by the Act. For, my lord, 20 persons elected by the Central Standing Committee of the All India Mohammedan Educational Conference. So, my lord, the link, my lord, with the foundation is here. Then, my lord, kindly come to subsection 6. It's very important, my lord, that the statute has to be read in a way in which Aziz Basha did not read it. And Basha did not even look at this. And Basha ignored the purpose, which is writ large over this. Now, my lord, kindly come. 30 persons, subclause 6, 33. 9 persons to represent Islamia colleges and other Muslim educations not under the control of the university. And then, my lord, 15 persons learned, then 9 persons learned in the Muslim religion and Oriental studies. Then, my lord, kindly come to the Executive Council shall have 30 members. And 3 is important, 6 other members to be elected by the Academic Council and 20 shall be elected by the court. Now remember, the court, my lord, is all Muslim at that point in time. We've seen 23 provisos, my lord. Then, my lord, finally come to 22. Top of the page, 2 persons elected by the court. Just mark these, my lord. It's just, the purpose is self-evident and control is self-evident. This is the Academic Council. Now, my lord, come to 19. This was there in the original act, my lord, and the original statutes. I won't read all of 19, my lord, but kindly come to subclause 9, 10, 11, up to 11, my lord, up all the way down. What does it say? What shall the departments be? Sunni theology, Shia theology, Islamic studies, Arabic language and literature, Persian, Urdu, law. These are the few institutions in India that protect Urdu, which, as your lordship knows, in the 8th schedule is important. When I went to Pakistan, my lord, they have protected Urdu in a way in which we haven't. Of course, I have a quarrel with the 8th schedule, my lord. English is now an Indian language, whether we like it or not. It is. You look at the literature, you look at the poetry, you look at everything, my lord, all the proceedings of this court. There's no point taking this anti-colonial view that English is as much an Indian language and developed as an Indian language. My friends in England, my lord, used to say, you've twisted the English language and adopted it as your own, which is true, my lord. And as Mr. Sibbal points out, we do it better than them. But anyway, my lord, that's not the point. Then, my lord, no. 21, my lord, at subclause 2 on page 23. Graduates of other universities who have been educated for the last 2 years at the Mohammedan Anglo-Oriental College. Link again. Then, my lord, kindly come over the page. And we see the foundation members who are part, my lord, of the court. I won't read out the names, my lord, your lordship will just note them. Lord, we giving degrees through first Calcutta and then Allahabad.
Was affiliated to Calcutta.
Affiliated and also
Later with
Allahabad, that's right.
From Surat also, there's somebody from Surat.
So, my lord, I'm sorry. Very good.
It can, a minority college, it can get affiliated to a university and get a degree from there. But in the case of a university, that cannot happen. So if you want, and if you, without a university degree, you can't get employment. So the real problem is if you say that I should have continued as a minority institution, nobody would have been employed. Because you have to get a degree, and that degree has to be recognized. So if you are a university, it's the act itself that must infer that this is the issue at the heart of the problem.
Section 6.
Mayor College was affiliated with Allahabad. Correct. I am saying that as a college, but once you create a university, it can only be done by statute. There is no other way to do it. Basha says you can have a university, but that degree will not be recognized. But that's not the answer to the question. If that is not recognized, why would you have a university? I'm just.
No, the importance of Aziz Basha is saying that universities are a part of Article 30. It says so in so many words, and that they have a right to be recognized by a minority. If that is so, my lord, we can't say tertiary education, my lord, is beyond the scope of 30. The fact that there were degrees through affiliation is really irrelevant now. Because of the negotiations that took place. You take my property, you take my people, you take the students, you take everything and the staff. Because it was essential, my lord. Of course, there was no Article 30, my lord. But apply Article 30, my lord, to Aziz Basha under the 20 Act. The whole point is the purpose of the Act was Muslim in character. And the purpose is nowhere to be found in Aziz Basha. Now, my lords. Now, my lords, I just note the pages, my lord, I just want to take your lordships, my lord, to my submission at page 61,
Page?
volume 1A.
What page, Mr. Devan?
61. Sorry, 16. Shall I continue after lunch, my lord?
Yes, we can resume after that.
But I want to upload my submissions.
Certainly. Give them to the notary councils, they'll make them a part of the compilation.
Mic check, 1, 2, 3.